Hi there. Missouri versus Jenkins is a fascinating case that spins a very interesting tale about the desegregation of American schools. And so I'd like to spend a few minutes talking about school desegregation and hopefully providing a little bit of context for the reading that you'll do related to Missouri versus Jenkins. Now, there's a result. This is a case that went to the Supreme Court. A lot of the emphasis in the text in this article is focused on the action below, what actually happened at the district court, because that's where the story is actually told. The Supreme Court ultimately ruled that the remedy that was put in place by the district court over the sort of 18 years of this case being in and out of the court was an overreading of Brown versus Board of Education. And so the Supreme Court accomplishes a couple of things. They limit the application of Brown versus Board of Education to what's known as de jure segregation. De jure segregation is segregation that is a result of the laws that are passed and implemented. This is not taking into account de facto segregation that may occur for a complex of reasons, many of which won't be easily recognizable as a de jure or a legal source. Right? And the other thing that it does is it limits the remedy to basically intra-district or within the district remedies, right? And I'll get to that in a little bit because it does raise a number of really interesting questions about how we are looking at the process that led to the inequities that are being addressed in Missouri versus Jenkins, and how we should look, accordingly at the solutions. It raises a number of interesting questions. None of them are easily resolved, so it really is something the courts kind of wrestle with. But there are some interesting things to note in the history of this. Now, most of you have learned in your primary schooling, Brown versus Board of Education in 1954 was the case that desegregated the schools, air quotes, right? It basically made segregation, legal segregation of public schools illegal, right? What most people don't realize is that the case was split into two parts and both of them are problematic because of their vagueness. For instance, essentially, Brown versus Board of Education in a relatively brief 14-page decision essentially says that the segregated educational facilities are inherently unequal, and for that reason, they must violate the Equal Protection Clause of the 14th Amendment, which really should have been the result in Plessy versus Ferguson, right? But by 1954, there was so much more sociological data. There was sociological data at all, right? And research that had been done into the phenomena of segregation and its impact. And so they were willing to go that far, right? Now, that's a very significant step, right? But we have to recall that basically all it does is reverse the precedent that was set in Plessy versus Ferguson, wherein it was decided that separate but equal does not violate the 14th Amendment Equal Protection Clause, right? What it doesn't do is give a solution, right, or a remedy to anyone. So they're back at the Supreme Court the following spring, and they did Brown 2. Brown 1 to Brown 2. And in Brown 2, essentially, with slightly less vagueness, they basically say, desegregate the schools with all deliberate speed. That's their order, right? And so the decree goes out throughout the land, and then we see a number of scenes from the history books or from documentaries that showed the tension that ultimately had to be resolved in some cases by the intervention of the National Guard, so to just keep the peace as the schools were desegregated. Now, when I say that Brown 1 and Brown 2 are vague, that is with the benefit of historical context and then seeing the different strategies that different districts attempted to use in order to fulfill requirements of that order. And this came up during our recent presidential primaries, right? When the history of busing came up in the course of the presidential debate, or the primary presidential debate on the Democratic side. Why it came up is because the resolution of this one issue, busing, did have a very significant impact on that generation, including mine, of young African-American students. Different districts went about the process in different ways. They tried different solutions. These included things like busing, like magnet schools, like talented and gifted programs, right? And all these programs and other types of programs, art schools, specialty schools, right? All of these different programs can be traced back to some of the principles that you'll be looking at inside of Miller versus Jenkins, right? And so Miller versus Jenkins is one of those cases, and there are a number of them, that come up to address what is meant by Brown 1 and especially by Brown 2 with regard to fulfilling the requirements of that order, which applies to all school districts in basic perpetuity, right? If they have a segregated school system, then they have to kind of factors to wrestle with, right? What does it mean for a school to be segregated? Certainly, in the time of Brown, what it meant was that only white children are allowed to go to this school, and non-white children have to go to that school, right? That's what it formally meant. What it actually looks like in the present day is very different, because in many places in this country, schools are as segregated, maybe not as they were in 1954, but they are often somewhat segregated. Schools can be somewhat segregated. If you're from a cosmopolitan area, it's not that they are excluding children from schools based on race, but residential patterns create a certain weight within certain communities, so that some students go to some schools and some go to others. It's not a perfect quote-unquote segregation, right? But there are whole counties that maybe sort of have one student population, and then another county might have another, right? And it won't be because there isn't some racial diversity, but it will in some part be driven by the fact that as much as we don't like to talk about it, after Brown versus Board of Education, some white parents began to pull their children out of these newly multiracialized learning institutions. And so it resulted in a weird phenomenon where in the late 20th century, schools were desegregating and then sort of resegregating, and an odd miasma of intertwining parent ambitions for their children. And what this illustrates for us, and many of these interventions were the result of court cases like Miller versus Jenkins, right? But what it illustrates for us are the limits of court cases to resolve some of these issues at all, right? And certainly where rights are being trampled upon, there is a need for the court to come in and then provide some type of solution. But then the problem then becomes, right, the norms. And norms, again, are those things that sort of underlie and predate law, right? Our expectation of how we will interact with our fellows, right? Those norms hadn't, they reached the point where everyone sort of was becoming aware of segregation and its impact because of the hard work of generations of civil rights activists, lawyers, and what have you, sort of raising this issue, right? In 1954, this had reached a point where it could be acknowledged even on a Supreme Court constituted in the 1950s that the systematic separation of the races in public schools using taxpayer dollars is not correct under the 14th Amendment, right? And that norm certainly is a powerful one because they wouldn't have acknowledged it if there wasn't very strong evidence for it. And again, generations of sociologists, psychologists had sort of studied segregation, and they can tell you exactly what it was doing, right? The problem then becomes, what's the new norm supposed to look like, right? Are little black girls and little white boys immediately supposed to start holding hands in line, you know, and they're sort of walking the kids in line, oh, kids hold hands. Is that immediately going to be the norm? We had not been conditioned for that norm, right? And so the Supreme Court was at a loss both, you know, legally, right, for what to do, and intellectually and spiritually for what to do, because the process of changing norms doesn't originate from within the Supreme Court, right? And if Brown were first coming up today, it would be a totally, you have different expectations. I don't know how, you know, what that world would look like, but our expectations are different because incrementally the norms have changed. Yet and still, we still have segregated schools, and this is based in history, right? It's based in historic housing patterns, residential patterns, and in a number of other factors, one of which was the resegregation of schools. This is something that confronts the Kansas City Municipal School District in the Jenkins case, right? And they are dealing with this, obviously, in response to parent concern. And their solution is to sue the state of Missouri, right? And this is a very interesting position to be in. The municipalities have a distinct existence, and they can, you know, their agencies have their own sort of agency and autonomy, and they can sue, right? So they sued the state, and this is where it sort of gets interesting because well, number one, we can talk about the motivations. The motivations would have involved inferior facilities and capabilities to educate the numbers of students that they would have had in the Kansas City Municipal School District as compared to the suburban schools, right, which were becoming, you know, more populated with sort of ex-urban whites, and as opposed to the city schools, which were being populated more so by those black and brown people who were left behind, and some whites, right? They would have been more crowded, they would have had less funding per pupil, they would have generally had a more working class or possibly impoverished student parent base. And so many of the quote-unquote extras that sort of come with having a wealthier or more middle-class parent base would have been felt, right? But in addition, things like facilities and all of these things would have been impacted by the wealth of the community because local schools are largely funded by local taxes, meaning within that district. More local than the state level, the county or the city, or whatever that local governmental entity is that's over that school district. It comes from those local taxes, property taxes, and local taxes related to that, right? And so we've got a new sort of problem, right? even to define this as segregation, right, might be subject to challenge, right? There are those who might say that where people choose to live, right, is not uh, subject to government choice, right? Individual choice, and where those schools happen to be and how those schools happen to be financed is a matter of simple, you know, how that state and how that local government is arranged, right? So it's simply, you say it is what it is, right? That's the new phrase. Um, the problem with that, right? To look at why the parents and the school district might have teamed up is that those residential patterns are not purely the result of personal choice. Right? Some of those residential patterns are the extended result of the segregation that created the problem in the first place. Right? Because the housing segregation would have made it easier to establish schools that were segregated, right? And so these things are tied together historically, even if they don't currently exist in a historical form, right? And so the fact that many of the people who were most sort of in pressing needs, right? You get one chance to raise your child, right? You're impressing sort of need from their perspective of finding good educational options for their children have nothing to look to other than outlying districts which are getting better treatment by the state, right? And they're not going to look at it and say, well, that's X county or Y county and they're just wealthier, right? All they're going to see is that the state has superior facilities for those children and inferior facilities and resources for our children. It is a really sort of, it's a driving problem if you're a parent, right? And if you're a school district and you're sort of looking at the fact that, okay, I have the more populous school district, for example, if you're in a larger city, I have, all of these, all of these children to educate and fewer resources with to educate them in a system that is ostensibly under the state, right? What am I to do, right? So they took the step of actually joining together and filing suit together against the state of Missouri, and that's how you get Missouri. So the Kansas City Municipal School District sues the state, upset about resources. It's ultimately overturned by the Supreme Court and limits that, the case in those two ways, limits it to sort of, limits Brown to rectifying the jure or sort of legally enforced segregation, right? And limits remedies to intra-district remedies, which we'll get to in a second. But what was the impact of Missouri versus Jenkins? Well, it's very interesting. It sets up a very specific way of thinking about the remedy, right? First, the story of how the case was litigated is very interesting, right? The two school districts, large school districts within the state of Missouri, are Kansas City Municipal School District and the City of St. Louis. Turns out both cases were being litigated at the same time, and they both came to significantly different results. The willingness of the court to look at certain types of evidence or to consider certain things at the act of counsel is basically what the difference was. Take a look at the article, and as you're looking at the article, look at what it is that the court is resistant to, and that tells you a lot about how they regard the concept of educational equality, because ultimately that is a part of the fight, right? if educational equality is the goal, right, then there are strategies that you can take, but you still have to decide which strategy to take, right? But if, as the Supreme Court states, right, subsequently, it's only de jure segregation that is prohibited, then in fact, it becomes a question of whether it's truly educational equality that can be advocated here at all, right? But over nearly two decades, right, the district court does strive to cobble together a solution, but it's not willing to consider inter-district solutions, right? So it regards this, it's trying to regard this as an intra-district violation, meaning it is within this, I will say artificial, but that's not pejorative. It means it's just simply a created choice, right, of where to put the administrative emphasis, on this. This will be Kansas City. All of the schools within this district will be, administered by, right? And ultimately, these divisions are created by the state, right, through some charter or through some choice that's made by the state and how to chop things up, right? And so an intra-district violation is one that occurs or is regarded as occurring entirely within that artificially created boundary, right? And an intra-district violation, if it were recognized, would expand the court's ability to recommend solutions like that, which was actually recommended by the plaintiffs, which was, among other things, including more resources, but among other things, it included things like busing or inter-district bus transfers to out-district schools, right? For children within the district, perhaps an exchange program, right? This was ultimately rejected in favor of inter-district solutions, which involved a number of things, including pay rates for teachers, proposed as basically in order, and other things like these programs I mentioned before, right, that were intended to increase the segregative or desegregative attractiveness of the, yes, it's a term, so desegregative attractiveness. If we can increase the desegregative attractiveness of Kansas City schools, we will in fact create desegregated schools because white families will be attracted to public schools, right? And this strategy continues to this day. But Missouri versus Jenkins was one of the pioneers of this strategy of trying to different programs and then looking at different metrics afterward to sort of measure, right, educational attainment or educational equality. And so this notion of educational equality sort of seeps through, right? It is unclear to me, at least from reading the article, and certainly even just thinking about it as a parent, right, what that means in the context of desegregating an entire school system, right? I can certainly look at educational attainment for one particular child, mine, right, or, but when I'm trying to sort of measure what that's supposed to mean, measure the value of that education, measure whether it's preparing students for the world that they're going to face, that becomes a lot more tricky at the macro level when you're not dealing with an individual. And that's what they're essentially trying to do. And it becomes apparent that everyone is just basically trying, hopefully as hard as they can, to come up with ways to come up with a resolution. So there is this tension between the inter-district versus inter-district relief. They have different standards. Why does the distinction matter? Essentially, it's because if you can propose different solutions if it's an inter-district, between jurisdictions, right? But in order to find that, you probably have to find something, given how the cases are, not gone, right? You probably have to find something like an intentional sort of drawing, separating, carving off of poorer or more sort of browner schools from white schools in order to create, right, these segregated patterns. But again, the fact that the court is loath to consider, right, it limits the consideration of other historical factors that have produced the housing patterns that have created the part of the problem that we see, then they're sort of limited. And they're also limited in that they don't want to move too far ahead of the norms, right? The other tension in this case is that, well, what will the white parents do if we make their children, black themselves into browner schools while white children are being blacked out? How would the white parent react? How would you feel, right? If you were satisfied with your school and they're going to send you to a school that is essentially in development, right? The challenge is very significant, right? So part of maybe Judge Clark's choice may have been that this is actually more expedient and I can actually sort of oversee something like this, right? Whereas it would be more difficult to multiple sources of contact, right? If you're trying to work an inter-district solution as opposed to an intra-district solution, which is what he proposed. And the creation of the program, right? It's also them having to come back and sort of check and then relitigate whether they are in compliance or not. But the fact that Judge Clark was unwilling to look at certain of these sort of extra, sort of outside the context of what actually was going on in particular schools, right? He wasn't willing to look at some of those things. It limited a lot of the remedy that was able to be found, right? And that comes out, as the article notes, the St. Louis case came out with solutions that sort of did provide opportunities for brown students to be dispersed into the community at large, right, through the desegregation plan. And the outcomes that were measured years later saw that black and brown students in St. Louis were having better attainment than black and brown students in Kansas City, right? So this, I'm not going to call it a myopic view, but the limited view that was adopted in the Kansas City Municipal School District case limited what relief, in some way, you could think of it, limited what remedy the court could actually apply, right? And so you'll see that reflected in the article as well. Now, when we talk about the solution that he did, go with, these programs were designed to increase the desegregated attractiveness of the institutions, right? Attract white students back, reduce some of the ills kind of go away, right? Because resources will start to flow back into that school if there are more white students there, right? This notion of desegregated attractiveness. These programs are many of the programs that you're probably familiar with from having attended public school, if you attended public school at any time from the 1980s on to present, right? You'll probably see some reflection of that in the development of this case law because of the result in this particular case once it got to the Supreme Court, or rather because of the process of right? So that process was the process undergone by many schools who have had to litigate in this area, school systems, and that is to achieve unitary status, right? So unitary school district is one which has met the requirements of orders that may have been issued under Brown versus Board of Education, right? And so part of is a value judgment that is based on what it is that the school has done to achieve said status. But what unitary status does not mean, it does not mean that the school district has eliminated all of the past vestiges of discrimination, right? And so, since it doesn't mean that, it must mean something else. And part of that is what the Missouri court, Missouri versus Jenkins court, is approaching, where it basically rules that this is, we're talking about de jure segregation only. So if we're talking about de jure segregation only, then we're not talking about eliminating all the past vestiges of discrimination. Why are we not talking about that? Part of the reason might be because it's unclear how a court would affect the norms that are implicated, right? Certainly, it can outlaw a practice that is on its face illegal, de jure, right? A lot of the ills that have plagued school districts like the Kansas City Municipal School District include things that have been impacted by past laws, right? They may be subject to laws that are sort of designed non-racially, right? They may be sort of cultural traditions and other choices that people make as individuals and a group, right? So it is fairly difficult to get beyond a certain amount of remedy when you're talking about a court case. Now, for the Supreme Court to limit the court's inquiry only to the de jure portion, right? It does tie courts' hands in ways that are interesting. I'll just say it that way. Right? And it does, in fact, limit where a court may find, because we don't know all of the factual scenarios in which one could sort of make allegations, right? It's not possible to know such a thing. It is an interesting choice to take that out of the hands of the district court to determine where it's seeing a problem based on the very, very broad, very, very vague language of Brown 1 and 2. One other thing, I don't always reference the specifics of Justice Clarence Thomas, but since one of my mentors, Professor Derek Bell, made this observation, I will pass it on to you. And it's a fairly radical assertion, which Derek Bell wouldn't have been unhappy to hear, right? But he said that the Supreme Court might have had a better strategy in affirming, affirming Plessy versus Ford, right? In Brown versus Board of Education. This is something to think about. What if the Supreme Court affirmed Plessy versus Ford, right? Affirmed it, and then basically demanded that the state basically provide equality where institutions and facilities are separate, right? How does this play into Clarence Thomas? Clarence Thomas's argument is that the solutions that were proposed in Clark, right, and the solutions that were proposed in all of these other desegregated cases made the presumption that black children in particular, or black and brown children, desegregation impacted all of them, right, that these children had to learn in the presence of white children, and that you couldn't provide a high-quality education outside of that system. So, how are these comments related? Because the spirit behind the comments is similar, although they're coming from very different political standpoints, right? Thomas is arguing from Justice Clarence Thomas is arguing from the perspective of a conservative constitutional theory, right? And Derek Bell is coming from the exact opposite, like almost polar opposite position, right? but they came to the same conclusion that maybe all of these cases are focusing on the wrong thing. Right? There may be something wrong, right? But it's not that black children can't go to school with white children. Fairly, why is that radical? And accordingly, Derek Bell's comment about Plessy also radical. In a way, it's a strain of thought that smacks in the face of all those people that work so hard to put Brown together, right? And that we're showing, all these studies that show that black children raised with lower self-esteem, lower educational attainment, less positive view of themselves in relation to their society, right? Subordinated, right? The solution to that, right, is integration, right? But Thomas and Bell seem to be saying that how about we do something else? Bell specifically is saying just put the resources where they're supposed to go and let the people live where they live and go to school where they go to school. Right? Thomas is basically saying the same thing, if you see what I'm saying. So it is an interesting philosophical choice that we've made to deal with school desegregation in the way that we have. And the many fascinating tales that kind of come out of this, are the stories of parents just trying to get a decent education for their kids, right? Because their neighborhood school, they have certain problems, and they don't see a way to sufficiently, get their child educated to their expectations, and to at the same time, maintain the life that they got, right? So it's a serious kind of existential kind of question. How will I get this kid? Right? That's the complex. And the court just doesn't have a fulsome solution. And part of that might be because the norms are still changing. Our expectations are still emerging. And over this past 40 years, 50 years, it's been a fairly challenging transition from the society that we had in which all black children were typically segregated 60, 70 years ago, right? To a situation where now, they're not necessarily going to be strictly segregated, right? But you may find yourself in a place where you are overwhelmingly surrounded by one ethnicity or the other. As I saw in my own high school, right? As residential patterns changed drastically, right? In 4 years. I went from being in a high school that had many white children to a high school where it was maybe 25%. And that, has only decreased in the years since then, if I were to go back and visit. So it's a very interesting situation. Bell and Thomas would argue that simply it being largely one school being 90% black is not, as my former high school now is, right, is not in itself a problem. And I can't necessarily argue with that on its face, right? But the history of how that came to be is complicated, and so it's worth a thought. And that's why Miller versus Jenkins is a fascinating case to study, an interesting story to learn about as you read it. And I look forward to your learning more about this and just having a great time understanding the different complexities and thinking about how they may apply in your own life. All right? I hope you have a wonderful day.